This meeting is being recorded.
Paul, you're muted.
Good morning and good afternoon.
This meeting is being recorded.
We'll go for a take two. Luckily, with the cloud recordings, this embarrassing bit will be cut off when we put this on YouTube afterwards. My name is Paul Daly. I'm the University Research Chair in Administrative Law and Governance at the University of Ottawa, and I host the annual Administrative Law and Governance Colloquium, of which this year the theme is Artificial Administration, Automation, Digitization, and Artificial Intelligence in Public Administration. And for today's session on algorithmic accountability in public administration, the GDPR paradox, I'm very happy to be joined by Dr. Sunny Kang. Dr. Kang is Global Privacy Counsel at Visa. She specializes in comparative privacy laws in the US and the EU. Additionally, she is dedicated to clarifying and enforcing the General Data Protection Regulation, the GDPR, to raise online privacy standards and algorithmic accountability. Her educational background includes an LLB from University College London, an LLM specializing in intellectual property and technology from the University of California, Berkeley School of Law, and a JSM focused on transatlantic data protection laws from Stanford Law School. She is the former International Consumer Counsel to the Electronic Privacy Information Center. There, she counseled on US and EU data protection frameworks and regulatory affairs on consumer privacy. She also worked as Senior Privacy Counsel, Head of Policy at Infor Inc., where she was the lead counsel on global privacy and AI governance. In that role, she submitted briefs to the US Federal Trade Commission, Office of Management and Budget, National Institute of Standards and Technology, House Financial Services Committee, Office of the Privacy Commissioner of Canada, and the UK Information Commissioner's Office on Data Privacy and AI. Now she is at Visa by way of Eightfold AI, and I think this mix of academic expertise and practical hands-on experience gives her a valuable platform to speak to us today on the GDPR paradox. So, Sunny, over to you.
Thank you, Paul. As a Canadian, I'm really happy to be here. Just to clarify, I do have advanced degrees, but I never quite went for my doctorate. So I am not Dr. Kang. You can just call me Sunny. Yes, I'm really happy to join. I just joined Visa as Global Privacy Counsel. When Paul asked me to present in this colloquium, I was working at an AI company in Santa Clara called Eightfold AI. And before that, I come from a background of consumer protection laws and tech policy. So I hope to bring together a blend of academic research that I've done into the GDPR and what it means for the uses of AI and automation in public decision making, as well as some of my practical in-house corporate counsel advisory perspectives as well. So if everyone can see my screen. Paul, everyone can see my screen, right? Okay.
Yep, all good.
That sounds good. Yeah, so my presentation is on the uses of decision-making systems in public administration, especially in federal agencies that deal with enforcement and policymaking. I approached this research as an attorney who was really passionate about the intersection of law and technology and public policy. And I wanted to have a conversation about the uses of AI in government because there weren't that much discussions about it. It was all very focused on private sector, commercial uses of AI and the threats that poses to civil society. But a lot of the examination of what it means for governments to rely on these tools was not front and center of policy discussions. So when I was at Stanford as a fellow, I was on a sabbatical from the Electronic Privacy Information Center. I worked on a project on algorithmic accountability in the federal administrative state. I believe that you've already had a seminar about that before. And I liaised with stakeholders in regulatory agencies to canvass what use cases of machine learning were being deployed and what democratic safeguards existed to honor the rights of due process, equal protection, and judicial review. And this is all because there is a lot of interest and demand for technologies to streamline difficult human tasks, especially with the increasing demands of modern governance. But of course, this should be done with the same legal principles that apply to human practitioners, such as transparency, accountability, and explainability. So right before I started this research, I was scrolling on LinkedIn and I saw a post about the use of artificial intelligence in China's social credit system. And this system is depicting a black box algorithm being deployed to monitor citizens and to import social control. And it's a very commonly known use case of AI in a dystopian setting. And it's often what we talk about when we're talking about robots taking over. But what really struck me the most when I was looking at this post about the China social credit system was the comment from my European colleague, which said, thank God in Europe, we have the GDPR. And what she was referring to was in the GDPR, there are myriad of provisions which place limits on automated data processing, particularly Article 22, which places safeguards on algorithmic profiling and gives certain remedies for individuals to access what data was collected about them and input it into machine learning systems. While it is true that the GDPR is a pioneer in AI regulation, it is indeed charting the way for international regulatory standards for emerging tech, but it is too soon to give thanks to the GDPR for protecting the EU, let alone global systems against all harms and implications of public sector AI, because it hasn't quite guaranteed that with the current legislative scope that it has. So this comment became a catalyst for my research because it seemed very complacent about a section of the law that has actually not really been tested in action. So, currently the literature to date focuses on the impact of AI in the private sector, and it deflects really extensive review of automated enforcement tools in public administration. This might be because it's not easy without having a research team and authorizations to speak to people in government to understand just quite how much AI R&D is out there and how normal it is and how pervasive it is at the same time. But the potential for these tools to abrogate procedural guarantees of constitutional and administrative rights is as potent in the EU and the US as it is in China, which is why my research hopes to start a dialogue on public sector uses of algorithms. Every tweak in these tools in government, especially in how the data is collected, what data is collected, how it's labeled, how it's modeled for predictive use, what types of AI systems are being deployed, can have potentially discriminatory impact. And that's why agencies have to be alert to the fundamental interests of due process and open government when harnessing the efficient powers of AI, because these AI systems are inevitable in government as there's just more information to parse out. But these guarantees shouldn't be buried in the presence of new tech. So in a couple of years, I have been working on this for a while, and I moved into private sector. I worked for an AI company, and it has refined what I think should be suggestions for sustainable innovation going forward. So when I first took on this research, it was from a more prohibitive standpoint, but now that I've worked with engineers, I know different AI systems and their trade-offs. I will talk a little bit in the end about what suggestions are out there for sustainable innovation and the practical steps that we should take forward. So it's not just the EU that I'm going to be talking about. It's just decision-making systems in different governments. And in the US as well, since 2017, the House and the Senate have introduced several bills to create an oversight committee over AI development in federal government. There's been several iterations of what is called the Algorithmic Accountability Act, which ranged from creating committees in federal government to just discuss how to use AI in public government, to also empowering the FTC to make regulatory rules on sensitive systems and potentially black box systems. There's also lots of initiatives by state and municipal governments. So for example, the New York City Council was the first municipal legislature to introduce an algorithmic transparency bill to apply to government deployed systems. And now the New York City government has also passed a law overseeing the uses of AI in employment in the private sector. So it's already a reality that almost all federal agencies in the US use automation to streamline regulatory functions to at least some extent. So for example, when I was working on this project at Stanford, we spoke to Securities and Exchange Commission, and they use an AI system called topic modeling and natural language processing to parse through narrative trade disclosures to predict non-compliance with financial regulations. Sometimes the EPA can use AI to target enforcement on potential violators of the Clean Water Act. And tax authorities all over the world, not just the US, are developing automated fraud detection systems to predict identity theft, to automatically withhold tax refunds upon signaling of a potential fraud. And there's really two significant concerns with AI in government is that if the government is procuring AI tools from private vendors and contractors, they will be instituting essentially a decision-making system that will be very hard to explain to the public due to the proprietary nature of the vendor's AI systems. And it's also going to lead to more interagency data sharing and repurposing of PII across different government agencies. And this also has to comport with data protection regulations as well. So as different governments all over the world are deliberating and developing AI systems, it's important to learn from the implementation of the GDPR to understand what safeguards are needed to address these challenges, what loopholes there have been in the GDPR, and also which measures have amounted to inadequate because of these loopholes that were not addressed. So the AI governance framework in Europe really evolved for a long time. The European Union began with restrictions on automated data processing in Article 15 of the Data Protection Directive of 1995, which is the predecessor to the GDPR. This created a right not to be subject to automated decisions produced by computerized systems without any human intervention. And this marked the inception of binding European legislation on automated systems that threatened individual rights. And the policy rationale was to preserve human dignity and agency against the advancement of machine-led evaluations of personal data. There are also German legislatures and French legislatures that took into account the horrors of war and how information played a part in enabling profiling and targeting individuals. The directive's explicit adoption of transparency on the logic of automated processing really reflects an incremental concern from the late 70s to 90s on the erosion of individual liberty by the impersonal treatment of computers. So from the European Commission's introductory proposal of the GDPR to the final adoption in 2016 and then implementation in 2018, the GDPR underwent thousands of amendments. It's a landmark data protection law, but it's also a product of years and years of political and institutional compromises and negotiations made amongst EU stakeholders. There's a lot of legislative deliberations that led to some AI provisions being watered down, omitted, added, and amended. And some of the policy objectives that were prioritized throughout the negotiations, as I will speak about, is the ability to give agencies the flexibility to develop AI tools to combat rising fraud in tax enforcement purposes and other enforcement purposes that might require more information. In the end, the ratified additions in the GDPR are individual protection against profiling to curb predictive decisions based on a personal attribute, which might lead to a legal and significant effect on a person, and the right to obtain human intervention and to contest the automated decision. It also comes with data protection rights on accessing the information that is in the system, the training data. So the entire AI framework in the GDPR is, as you can see from the previous slide, a constellation of overlapping articles and non-binding recitals, which seek to explain but don't have the same power as articles. The GDPR essentially is a data protection approach to AI regulation, and now in 2021, the European Commission has proposed an AI law to complement it. But in the GDPR, the first focus is on data access by the subjects as a privacy legislation. So there are some cracks in the human in the loop provisions in the GDPR. And number one is that an individual needs to say that their data has been used in the system to say that they have suffered some harm from it. This leaves a lot of questions, especially given how technologically complex AI systems are, such as if an individual has been subject to an automated decision by a predictive model, but it's not trained on their data, it's trained on a data set of similar individuals, will these rights apply? What about anonymized data? It's quite easy to featurize and anonymize data that you put into a training system that doesn't have PII in it, but with the aggregate information that is out there, you can potentially re-identify people. So there's a lot of questions that are not answered by what exactly entitles someone to remedies for AI provisions under the GDPR. And there's also some loopholes around the fact that the GDPR focuses on sole automated decisions. So in order to claim remedies against an AI, you need to prove that you've been subject to an AI decision and that this was solely rendered by a machine. So even de minimis human oversight on de facto automated decisions, it begs the question of whether that would take them out of this liability. So for example, a lot of hotspotting police apps, it's rarely not overseen by a human because someone is inputting the data into a police blotter, someone is probably manning the system, but that doesn't mean that it doesn't have de facto automated impact on individuals if it is actually taken into action. And secondly, individuals need to claim that there's been a legal or significant impact to their rights. And especially in the private sector, unfair effects are not always illegal. It's not always actionable discrimination, even though it was against your informational self-determination or it profiled you in some negative way. So for example, there is an example of ads that are curated on racial proxies derived from innocuous data points such as zip code. If you see an ad that is clearly targeted for you on a racial stereotype, it's not actionable discrimination under any sort of non-discrimination laws, but it leads to an unfair effect. And this isn't adequately captured by the GDPR. Unfairness as a result of unintentional, implicit, or erroneous discrimination that produces disparate results is really not covered. So there's also national laws that preempt these remedies. In the remedy section, we spoke about the famous algorithmic transparency provision under the GDPR, but it also hasn't been clarified by the courts on how it would apply. And also, it's very unclear if an individual was to assert their right to contest the decision, whether that would only mean that they're expressing their point of view to the data processor instead of actually receiving some sort of remedy to correct the adverse impact that has been created by the machine. And none of these remedies apply if they're preempted by national laws. So for example, if a member state of the European Union has a national legislation to empower agencies to use AI for regulatory functions, as long as they provide guarantees of proportionalities and limitations, they won't be subject to these AI provisions and liabilities in the GDPR as long as it demonstrates some safeguard for human rights. And this also means that because the European Union consists of many different member states with different cultural norms and rule of law indexes, that these standards may be inconsistent across European countries with different regard for human rights, civil liberties, and the maturity of their rule of law systems. And in fact, the GDPR expressly authorizes profiling and automation for targeting tax non-compliance. As you can see here, this would be a legitimate use that authorizes an exemption, but it opens up the door to a wide range of regulatory action being augmented by AI without specific thresholds. There is a lot of different AI systems in governments, and there's a lot of differences between AI for complaints categorization, which is not very sensitive, to profiling, which considers a lot of risks, as well as the extreme examples of facial recognition for national security and immigration. Yet it's really up for the European member states individually to determine what is legitimate enough to supersede the GDPR. And this leaves room for enforcement agencies to deploy algorithmic risk prediction analysis insofar as the profiling techniques are merely acting as measurement tools to guide human decision making. The GDPR provides a broad scope for derogations for public authorities. And this was a deliberate design to balance the interests of data protection with the growing demand for algorithms in the administrative state. So although the GDPR facially applies to both public and private sectors in their capacities as data controllers and processors, national governments may adopt supplementary legislation to sanction automated data processing as an official exercise of their adjudicatory authority and administrative powers. And this margin of discretion reflects a growing acceptance and demand for algorithms in the regulatory toolbox. And in order to understand and efficiently regulate the societal impact of privately deployed AI, the consensus in Europe is that public authorities must embrace the computing power of algorithms that can detect such negative externalities. So, for example, the competition commissioner of the EU, Vestager, she said that she would like the European Commission to have its own algorithms to be out there looking into the market, figuring out if there's been collusion taking place, alluding to pricing algorithms that can autonomously interact to fix prices without human agreements. In other words, she's saying that the public sector needs to reciprocate technical expertise of the private sector to build adversarial algorithms to detect and predict and prevent black box industry practices. Originally, the GDPR had proposed a blanket restriction on automated processing of special categories of personal data, such as data revealing ethnic origin, political opinions, and biometric information. But this initial proposal, as it went through these amendments, was significantly curtailed from prohibiting all decisions based on algorithms trained on sensitive classifications to enabling public authorities to use these systems if the empowering legislation provides a necessary and proportionate aim. And you can see here some of the examples of algorithms in the regulatory toolbox in Europe. So this shows that there's a lot of different ways that the GDPR allows for regulatory AI and how there aren't clear thresholds as long as the member states are exercising national legislation and creating some safeguards on how these AI toolboxes are to be regulated in the EU. Even the latest regulation that has been proposed by the European Commission, which is the AI Act, which came out April 2021, it echoes the same sentiments of the GDPR in the fact that the regulation should not hamper the development and the use of innovative approaches in public administration. But the question that I've been begging is, what exactly does it mean? Even though these regulations are purposefully meant to be technology neutral, it would be very helpful for governments to make the distinction between, okay, like this is a classification complaint system that doesn't actually make predictions on human profiling, to this is a convoluted neural net that poses a high risk, and these should be regulated in these ways. It tries to make these classifications, and there's the unacceptable risk, which involves some biometric data. There's the high risk, which involves tax agencies looking at personal data to predict non-compliance, as well as some hiring algorithms. But there aren't enough guidance on exactly marrying law, policy, and technology. And this is a problem because sometimes AI is trained on target variables which have very sensitive implications on individuals that are not related to the output that they want to produce. And it can also create a model that is replicating societal biases. So let's take the example of hiring algorithms. This might be for private sector use, but just to demonstrate how there's discrimination and bias percolating in the systems. If you set a target variables that is typically absent in protected groups, it might marginalize these groups and replicate these biases. So for example, if you have a hiring algorithm that is looking at how long an employee stayed at a company to determine loyalty, this might disadvantage many women who are more likely to leave the workforce temporarily due to childcare, or people of color who may not have been given the opportunities to move up, so moved out. And when you apply these potential biases to government algorithms, it presents a serious constitutional question on the permissible limits of algorithmic policy determinations, especially because so far the constitutional muster across the world is unclear on how personal data as well as proxy data that infers sensitive attributes should be labeled, categorized, and weighted in automated systems, and how courts will assign accountability for algorithmic disparate impact. So where do we go from here? I think that it's clear that the question of social equity and privacy should be at the forefront, and public authorities need to work with both lawyers and technologists to understand how does the civil rights framework, how does the rule of law framework apply to emerging technologies. And this might lead to very granular conversations that are specific to the type of model that you're trying to use, the type of basis of quantitative metrics that predict success in that specific model is trained and how it's overseen by humans. It's really easy to be blindsided by the intuitive appeal of AI, especially in bureaucratic government agencies, to just jump into an AI vendor and let them operate with proprietary confidentiality black boxes, and to let them set normative rules that might govern people's rights and property and livelihoods. But this clearly should not be the norm, because any sort of AI procurement systems should really look at potential biases, what the AI is trying to augment, and how it's led by humans. It's important to establish checkpoints for transparency and accuracy at each automated processing stage to improve data governance, data quality, and the opportunity to correct hidden bias, because a lot of AI systems, if they're trained on bad information, can keep replicating those historical biases. There's also the need to think about the cyber delegation of legislative authority to algorithms. And there's a really great paper called Regulating by Robot, which delves really deep into what it means for administrative agencies to cede judicial review processes, to cede autonomy in the public administration process to machines knowingly or unknowingly. Machines might be good at repetitive tasks, and that might be a sector where they prove the most useful to government agencies. So for example, a consumer protection agency that receives 2 million complaints, but only has 200 people on the staff, they might benefit from safe uses of AI to parse that information and to bucket them into different ways to prioritize and triage, and provided that they're actually checking how it's being triaged in the process. However, machines don't exercise critical moral skills such as empathy, the ability to make exceptions based on social context, to just look at outliers. And these are critical human skills that are needed in regulatory functions, such as setting pretrial bail, sentencing, determining non-discrimination laws, etc. What the government agencies should be really cautious about is the fact that once an AI system is already being used by that agency, the human becomes reliant on it, and they might overvalue the propositions set by the AI systems and just not use as much of their own independent judgment that they might have used before. So, humans might be blind to their own biases and consider the whole pictures. That's also a risk, but the risk of cyber delegation is that the human becomes reliant on that AI system and just fails to go through the due process and administrative procedures that they should have. There is also issues with autonomy. So, who is overruling who in a system like this? Is it the human that is going to overrule the AI system, or will it be vice versa? For example, pretrial bail. If an AI system decides to keep an individual in jail, we will never know the unobserved counterfactual of how these individuals would have behaved if not in jail. And the AI system will, at the same time, never learn to calibrate on whether its decisions were correct, which may lead to individuals with similar characteristics systematically being flagged as false positives for flight risk. And that's why it's really critical for AI systems to have clear goal setting and limitations and parameters of the impact that it's allowed to have, because applying discretionary judgment through an automated system in a way that impacts human livelihoods, it needs to be human-centric because it has a very, very deterministic human impact. And the AI system doesn't really learn from the unobserved counterfactual of, if its decisions were not correct in the first place. And machines as a proxy for human decision-making can insulate flawed decisions from scrutiny. And because machines can have the potential to hard code and replicate societal inequality, it might whitewash and make bad decisions seem objective because it's based on data instead of a human decision. And that might make humans more reliant on AI and not be able to justify their own basis for decisions. In the federal contractor processes, there's more AI vendors coming into play. And because of this, I have, in my capacity as corporate counsel for AI companies, I have seen some really great improvements in how AI vendors are vetted in this process. So there is something called AI model cards, which is a narrative way of explaining to different stakeholders what your model does, what are the trade-offs, what are the data sources, and how it can mitigate biases, and what safeguards and limitations you're putting into place for that. So in this process, I think some agencies are more advanced than others because they've just dealt more with emerging technology companies in the past, and there's been more public-private partnerships. But in the more advanced agencies, they do ask the vendors, where is your data coming from? Do you have the lawful basis to process this data? Are you processing data with regard to fair information processing, such as data limitation, data minimization? Are you anonymizing and pseudonymizing data when you don't actually need to have it out there in the plain text? Secondly, there's more discussions around quantitative performance metrics. So when people talk about AI ethics, it might sound like a very abstract concept, but there's a lot of different ways statistically to determine how accurate, how robust the system is. And some of these metrics are called AUC, recall, statistical parity, and parity is making sure that there are not more false positives or false negatives for one marginalized groups than it is for others. So there's different ways to baseline performance and success of your outputs, and these conversations are happening more in the federal contracting. I've also, although I can't disclose what agencies, I've also dealt with agencies that are very proactive and not making this too technical. So some agencies are okay with just a very proprietary document that has technical details, but some agencies might ask, okay, so you have this system in front of you and you're deploying it. Can you walk us through in a normal narrative way what human problem is designed to solve? And in in like all honesty, what are the risks that you foresee? And it's okay to list risks because all AI systems have them, and what are the mitigation steps you're doing? How can the government work with you to make sure that the safeguards are in place? There's also more practical examples of privacy by design principles. So there's a lot of data in AI, and in a way, it contradicts with the GDPR because the GDPR is very data minimalist. You want to minimize how much data you're processing, whereas a lot of AI systems really benefit from having more data in their systems because it leads to a more cross-sectional picture of the world. It leads to mitigated biases because you're just training from a wider data set instead of an echo chamber of potentially historical data. And privacy by design comes into play because in order to centralize more data for training systems, you might need additional privacy enhancing technologies to pool that data together without exposing it or centralizing it to potential data breaches. The European Data Protection Board has suggested several techniques, such as encrypting in computing, to making sure that you're anonymizing training data sets, to deploying some more complicated cryptographic techniques to ensure that when you are working with various different parties and you're bringing the data all together, that you can keep some of them siloed and that you're not just mixing them all together into a honeypot for a security breach. And finally, the new AI Act proposes something called AI regulatory sandboxes. What this means is there are some instances where government agencies might host hackathons where they give industries and startups and stakeholders a use case and ask them to do a hackathon and figure out how AI can be deployed safely to solve that problem. The benefit of a regulatory sandbox, which essentially means that you're able to play around without really limitation or risk, is that you have a regulatory agency who is overseeing it to make sure that you're clarifying the compliance on how do you comply with data protection laws and AI principles while also figuring out a way that an AI solution fits into a specific use case. So the European Commission recommends AI regulatory sandboxes to facilitate the development of innovative AI systems. And it's a great idea to an extent, but there are limitations to sandboxes as well. So number one being that often they are very abstract, and because of the lack of resources in government agencies to really interact with technologists, there isn't very interdisciplinary knowledge transfers that are happening there. And then secondly, it's very, it's abstract once again. And even when you come up with a use case that fits into an AI solution, it's really hard to actually materialize that into a solution that works in real life. So for example, there's been a lot of hackathons on financial information sharing for anti-money laundering detection. And in these, you work with AI companies and regulators to try to figure out how do you securely pool data so that there is more information for anti-money laundering detection? How do you do that with AI by understanding the substrates of different fraudulent activity? And how do you do that in a way that complies with regulations? And it's often, it's often difficult to use a hackathon idea into practice because the industry is still slower moving. There's lack of compliance, clarifications. So there are limitations, and also most of the participants who engage in these hackathons are already big tech companies. So it does lead to some more centralization of the big tech's interest in these AI solutions because they're already front and center of these regulatory sandboxes. But my point essentially in the end is that, there are many ways that the government might need to use AI systems, and there's different classifications of risk. Currently, the GDPR, as well as some of the new proposals for AI regulations, such as the AI Act of 2021, they don't provide a solid threshold of how governments can work with different stakeholders to come up with these solutions. However, there's a very distinct need for governments to be more forthcoming with emerging technology and work with not only lawyers and policymakers and engineers, but just different people who are impacted and civil liberties groups to understand how these solutions can be deployed in a fair way that complies with constitutional guarantees that people are entitled to. Thank you. I hope that helped.
Well, it certainly helped me, Sunny. Thank you very much for that, bringing us on that AI bender. If people have any questions, please do pop them in the Q&A, and I'll relay them to Sunny. I'm wondering if you could say a little bit more. It builds on a question that Amy Aria posed in the chat about the need for interdisciplinary perspectives in regulatory sandboxes. And I suppose I'm interested in any comments you might have on the process of working with engineers who are being tasked with respecting the GDPR and other legal and constitutional norms. What are those interactions like? Do the engineers appreciate the lawyer's view of things? Is there a kind of a dialectic, a back and forth as you try and work to a conclusion where the lawyer is happy and the engineer is happy? How does it work? And is it we in theory it's a great idea to have an interdisciplinary approach. Is it workable in practice?
It has to be workable in practice because that's the only way forward. I think even just in the recent years, I've seen really great developments in interdisciplinary collaboration between engineers and lawyers and policymakers. It took a lot of really bad precedents like Cambridge Analytica and Amazon's bad AI practices for these collaborations to come together. And also, this is a lawyer joke, but there's a lot of ego on the table with lawyers working with non-lawyers and engineering working with lawyers because no one wants to be told what to do. However, it is really humbling, especially for lawyers, to work with engineers and understand the systems and how it works and the different limitations it has. So for example, when I was a consumer protection counsel at a nonprofit in DC, I remember being very headstrong about fair information principles and just saying like you should just comply with it and there should be no exception to it. However, when I collaborated with engineers, I learned that sometimes it's hard to be data minimalist when the AI system requires a lot of training data in order to produce accurate and robust results. And there's different instances where it's not always easy to contractually safeguard privacy when the vendor that they're using might have several security practices that you don't even know about. So there's many different worlds colliding here. With AI, I think, as I mentioned, with the federal contracting processes getting a lot better, facilitating these conversations, I am seeing really great strides here. Especially because it's getting more difficult for AI vendors to enter into that space without really thorough scrutiny and review.
Related to that and related to your response, Angelica Fernandez asks about the contradiction between GDPR and AI models needing more data. What are your thoughts on synthetic data to train those models? And will this be a solution to that paradox?
I think that's a really great question, and it's something that a lot of regulatory sandboxes have been framed around. So going back to the example of medical AI systems, they need a lot of data. Often it's really hard to get data because of privacy regulations in the healthcare system. However, having more data in that space has the paradoxical effect of being able to provide more accurate results in healthcare. Same with financial institutions. Often banks are very siloed and they are commercially disincentivized to share information with each other, even if that would lead to more accurate tracing of terrorist financing and money laundering activities. The solution is not always clear. I think people have different privacy enhancing technologies that they're currently developing, but they also come at some trade-offs. So for example, there's the third pillar of encryption. There's encryption in storage, in processing, in transit. People might use encryption in processing to pool all this data together and compute on the aggregate without sharing and transferring plain text data with each other. This sounds really great because it allows you to work together with people without actually revealing to them what information you have. However, the trade-off is that that creates an overhead of 10 to 100 times lag, and it's also millions of dollars. So I think synthetic data is another one of those examples that provides a certain solution. People do work with synthetic data, especially in hackathons. People also work with decentralized analytics. People work with differential privacy. And these are all really great solutions. Not one of them is the sole answer because they each come with trade-offs and usually have to be counterbalanced with each other.
On that theme of trade-offs and how you get these things to work in practice, Ushnis Sengupta asks about experience with AI regulatory sandboxes and posits that one can only test a limited number of cases in a lab, and it's the exceptions that really matter, sort of like drug testing. More adverse reactions show up with broader population use. And this goes to a theme that Catherine Sharkey touched on in her presentation, which kicked this series off a month ago. She's talking about how the Food and Drug Administration can use the adverse effects database to monitor what's going on with an approved medicine ex post rather than ex ante. You can use AI to do that. I guess the question here may be, is there a means of having a similar adverse effects database for AI, which would allow us to, have a regulatory sandbox and get something out there which is workable and working, but also monitor it on an ongoing basis to smooth out its rough edges?
Yeah, I am not familiar with the drug testing AI sandbox, but I think as we've seen from the examples that I've mentioned, it is really hard to control for some of these adverse impacts, even in a regulatory sandbox, because it depends on the data that you're working with, it depends on the use case, it depends on the AI systems, especially if you're dealing with unsupervised systems where it's working across immense data sets to extract meaning, to imbue very subjective sentiment analysis, and to navigate new social and cultural contexts. There will be adverse impacts that is going to be really hard to control for. So yeah, I'm not familiar with the drug testing example, but natural language processing and like some of the limitations of training there, that's an example that I would bring up.
So Natalie Heisler asks, thanking you for an interesting talk. Talking about disparate impact and bias, how do federal agencies determine the acceptable level of disparate impact in practical and statistical terms? in a particular policy context. Any comments on this inside or outside the GDPR context? I note as well, Natalie, that Teresa Scassa will be our next speaker in this series, and she'll be talking about the Canadian Directive on Automated Decision Making, which will also speak to some of those issues. But Sunny, over to you. In terms of disparate impact, what are agencies looking at in that respect?
So in my previous company, which was an AI and hiring company, I got to work together with the Equal Opportunity Commission in the US to understand how federal agencies are applying disparate impact laws to emerging technologies. Because these laws on non-discrimination in employment have been written in the 1970s, like the most recent ones are promulgated in the 1990s, it really didn't envision AI to enter into the space. But what the agencies are doing now is just applying the law as is to the AI systems. So in the US, we have something called the 4/5 rule, which means that the demographic groups with the least amount of selection rate shouldn't be less than 80% of the most amount of the selection rate. So there's that. There's also different metrics that are specific to AI, such as the area under the curve, which measures accuracy. There's also a statistical standard deviation control called the Z-score. As a non-technologist, I definitely would not try to explain the Z-score, but the Z-score is used by various employment opportunity commissions and federal contracting employment commissions to determine what's an acceptable measure of disparate impact. And this can also be applied to AI systems. And usually the agencies will work together with AI program vendors to understand what are they doing. Are they using target variables that are unrelated to hiring, or are they using job-related traits that are okay to use? So there's different ways to control what data is used, what sorts of metrics you're basing as the accuracy baseline, and how you're determining and overseeing accuracy and monitoring that in the process.
Thanks. In the American context, I guess I'd add that there's quite a bit of case law too on what exactly, and it's true in the UK as well, indirect discrimination effects. There's quite a lot of jurisprudence on those, which I guess helps feed into the tests that or standards that agencies are using. At one point in your presentation, this touches on a question from Juan David Gutierrez. You said that industry is sometimes slow moving, which I thought was intriguing. We tend to think of industry as being the leader when it comes to AI and developing new ways of doing things, with governments lagging behind. But I didn't get that sense really from your presentation, and I didn't get the sense that governments are necessarily lagging behind as much as one might think. The question is whether you think the use of AI by governments become prominent or remain marginal. So I'm wondering if I could push you a little bit more on that observation about industry being slow moving in certain respects.
So yeah, I think that's a really good callback, because what I was talking about was in terms of the results that we get from regulatory sandboxes, which mean different ways of looking at AI use cases, different privacy enhancing technologies that should go into design of AI use cases. Industry is slow to accept that there's different ways of training data for AI models. So even though AI systems are very fast moving, there's different use cases that are being proliferated. the privacy enhancing technologies that should undergird those processes, it's slow for big tech industries to accept that and invest in that. So that's coming from a more of a perspective of a startup, which was dealing with decentralized analytics for AI. So it's true that AI is being developed, but considering ways to develop that AI in a privacy compliant way that creates less risks, industry is slow to invest in that option.
All right, no, fair enough. Couple of questions from Justin Lee and Freya Vandenboom about data. How can data collected by government institutions, so for example, statistics bureaus, be shared with the public while remaining compliant with privacy laws? And whether, in fact, Freya asks, there should be a new right to access data held by companies at their servers to address some of the limitations of the GDPR access rights and the limited right of data portability.
I think having robust data subject access rights is very important, especially in understanding the inventory of what these institutions hold about you and being able to exercise informational self-determination and asking them to rectify data that might be outdated or incorrect, that might have had an adverse impact on you. However, this isn't the end of the story, right? Because even if you have your rights to access the data, what is missing is your ability to understand the context around how that data was being used, your ability to understand how your data is being aggregated and anonymized and put into AI systems, where after a certain point, you don't really have control over how these determinations are made and how these data points are analyzed. So there's a data subject access rights, which are necessary, but it's not the dispositive thing. It's not sufficient in itself. I think institutions should really invest into explaining the context around their AI systems, explaining to people when their data becomes aggregated and anonymized, if it is still going to be used for AI systems for training purposes, and how they can safeguard that with specific opt-in controls.
Speaking of controls, Sarah Bannerman thanks you for a wonderful presentation and asks your thoughts on algorithm auditing, which I guess could be public sector or private sector, or you have a general algorithm commission to audit public and private sector use.
I think if you had a government agency to audit various algorithms and have a process for algorithmic impact assessments, it is a very nice recommendation, but it would definitely not have enough resources to complete all of those impact assessments. Can you imagine a data protection authority doing the privacy impact assessments for every single transfer that is happening in and out of that country? You would probably never be able to do any business there. So what is really important is to invest in in-house auditing systems, in-house controls, in-house governance, risk, and compliance teams that know how to speak the language of engineers and product managers to work together and having these controls, because it's much easier to do these governance controls from within, where you are dealing with these systems every day. You are dealing with different errors that the system is producing and understanding, the limitations of it, to have an impact assessment with that knowledge than for an outsider to come in and try to regulate that and try to audit that within 2 weeks.
No, that's a fair point. I think we often think I'm as guilty of this as others are. I suspect that you could just establish a regulator and that would help. But the power to put things right is held in the government departments and in the private sector that are actually using the tools, and they maybe the issue is putting in place the appropriate incentive structures that those institutions in the private and public sector are doing things the right way, rather than setting up some sort of external agency. Time is running along, and Sunny has been very generous with it. A couple more questions, Sunny, if I can keep you for a few more minutes. So Freya van den Boom asks, looking at insurance companies in the United States, and she believes there's a requirement to provide access to risk score factors, whereas in the EU, there's no requirement to subject algorithms, factors, and weights for approval. And she wonders whether this should become mandatory when used in certain situations that would have a serious effect on people's lives.
I think that's a really great example because fair credit and fair lending systems have explanations of credit scores. And usually, even though these explainability metrics are not technical in any way, it gives the individual enough information and understanding about why your credit score has gone down. It's because you increased your revolving utilization. It's because you opened another line of credit. What can you do to make your credit score go up again? So that is a really great example of an explanation that really resonates with a normal consumer, that they can do something about it. They understand why that decision has been made and how they can work around the adverse impact. So I think that's a really great example. I am not really sure how European agencies mandate fair credit reporting acts, because I have not received a credit score in Europe before, but I think that in the US, that example, and there's a lot of good literature about it by the Consumer Financial Products Commission, I think CFPB Bureau. So I think the FICRA example is a really good one of how to make AI explainability work in terms of communicating it to consumers.
So one last question then from Justin Lee, and again, kind of on the theme of your responses to the last two questions. He asks, who should be setting the standards for algorithmic audits? Legislators, regulators, industry groups, academics, or I guess some combination of the above, perhaps?
Yeah, that's a really great question, because currently the legislators have not really provided a very clear threshold on how to do algorithmic impact assessments. The New York City Municipal Legislature recently passed an AI in hiring legislation that requires audits. But instead of explaining what would be required in those audits, they just say you need to get an audit from an independent third-party auditing provider. The thing is that currently there are no auditors that are specifically certified to provide algorithmic audits, because there are no standards that are in like internationally agreed upon. So in cybersecurity, we have ISO, we have NIST. There's lots of different standards for which an auditor can look at and create different controls to check off or to check. But with AI, we don't currently have these standards, so it's really difficult to know where to go. And I know that a lot of AI companies are struggling to understand what this requirement means. I think what is clear from this like missing piece of the puzzle here is that there wasn't enough industry stakeholders, there wasn't enough computer science PhDs that were in that legislative table when they were discussing what should be required in the algorithmic audits. And because of this lack of a very critical stakeholder, the law didn't quite connect to how it should be applied practically. So it should really be a conversation for all these stakeholders to be involved in together.
Well, thank you very much for your response to that question, and indeed for your responses to all of the questions. It was a very engaging presentation, Sunny, really fascinating. And as I said at the outset, the advantage you bring to this space in this area is your unique blend of public, private sector, and academic experience. So it was really enriching, and your answers to the questions have been fulsome and fascinating, and have opened up other avenues of thought and inquiry for me, and I'm sure that's true of our attendees as well. So it only remains for me to thank you, Sunny, for your time today, and everyone who wishes to continue on. We'll be back with Professor Teresa Scassa in 2 weeks to talk about the Directive on Automated Decision Making, the Canadian response to the rise of artificial administration. Thank you very much, everybody.